Good evening and welcome to the Hudson Institute. My name is Urška Petrovčič and I'm a senior fellow at the Hudson Institute. I will be your host today during this event on patent litigation in China. China has one of the youngest patent systems in the world, yet its laws and policies are rapidly evolving, having profound implications for companies all over the world. In the last decade, China has made significant improvements in the protection of patent rights. It has amended its laws, it has established specialized courts, and it has joined international IP agreements. China has seen a significant increase in domestic patent applications. It's also becoming an increasingly common patent litigation venue. In the last year alone, we have seen several patent litigations taking place in China, some of them involving international well-known corporations. Despite this improvement, some commentators point out that patent protection in China remains inadequate. In the context of standard essential patents, for example, there has been an extensive debate questioning whether courts in China should set rates for global portfolios of standard essential patents. There has been also an intensive discussion regarding the use of anti-suit injunctions. These are injunctions that have been issued in cases where firms had parallel litigation in multiple jurisdictions, including in China. These are, of course, questions that matter for companies that do business in China. However, they're also relevant for policymakers that are designing the US policy toward China. So to address these questions, we have invited a distinguished panel of speakers. We have with us Mark Cohen. He's a distinguished senior research fellow and lecturer at Berkeley Law. He has over 30 years experience in academic private law firm and in-house position involving Chinese IP and tech transfer issues. He formerly served as the first representative of the US Patent and Trademark Office in China, as a senior advisor to the Undersecretary of Intellectual Property, and as a senior counsel China at the US Department of Commerce. Other positions he has held include visiting professor, Fordham Law School, senior counsel, Jones Day, director of international intellectual property at Microsoft, and general counsel at a mid-sized generic pharmaceutical company. He's also the recipient of the Distinguished Civil Service Award from the President of the United States for his work on Chinese technology issues. This is the highest award in the civil service. We have with us Vivienne Bath. She's a professor of Chinese and International Business Law at Sydney Law School and Associate Director at the Center for Asia and Pacific Law at the University of Sydney. Her teaching and research interests are the international business and economic law, private international law, and Chinese law. She has first-class honors in Chinese and in law from the Australian National University and an LLM from Harvard Law School. She has also studied in China and Germany and has extensive professional experience in Sydney, New York, and Hong Kong, specializing in international commercial law with a focus on foreign investment and commercial transactions in China and the Asia region. Last but not least, we have with us He Jing. He is a specialized legal practitioner with more than 20 years of experience in handling complex China litigation, IP, antitrust, policy, advocacy, and compliance matters. He started his legal career as a US patent attorney, and he spent about 9 years in a major international law firm before starting his private practice in China. He was selected as a recommended intellectual property lawyer by Chambers Asia Pacific Guide and Managing Intellectual Property. He was the key consultant conducting the US-China Intellectual Property Dialogue. He also leads the policy programs as the executive director of, forgive my pronunciation, Beijing Zhongchuankun Intellectual Property Strategy Research Institute. Good evening, everyone, and welcome. So let me start with you, Mark. Mark, you're an expert when it comes to China's patent system. Could you talk a bit about patent litigation in China? What are the main features and how does it differ, if at all, from patent litigation in Western countries such as the United States or the European Union?
So a few things to talk about. It's actually a big topic, but to begin with, the Chinese court system is 4 levels of courts. It's a quasi-civil law system. Actually, case law is becoming more important. The judges, at least with respect to intellectual property, are specialized. China has a number of specialized IP tribunals, as well as 4 specialized IP courts and a national appellate IP court, like the Court of Appeals for the Federal Circuit. So there's actually a fairly high degree of expertise and specialization in intellectual property, particularly in technology-related intellectual property. Those aspects make it a little bit similar to the US in terms of the Federal Circuit and some of our judges who hear a lot of patent cases. It's a bifurcated system like Germany. So validity issues and infringement issues are separated. The Chinese courts don't have the final say on claim interpretation. That will go back to the administrative agency. As with many other civil systems, the injunction is more readily available than in the US. Doesn't have an eBay doctrine to limit the issuance of injunctions. And not only that, because of the growth of the Chinese economy, the injunction is especially valuable. If you can stop someone from making, using, or selling a product, considering the size of the Chinese market and the role of China in manufacturing goods, that injunction can be much more valuable than in a smaller market. Damages historically have been low. Discovery historically not available. Those things have both in the process of changing. Recent amendments to the patent law give a modest amount of discovery, particularly to determine damages. You can get punitive damages up to 5 times, but generally courts award statutory damages, and those damages remain low, although they are intending to increase. Jurisdiction is based on domicile or place of infringement, and the docket is large. The IP docket in China is several dozens of times more than the United States, although it's typically 1 claim in a case. It's not consolidated with multiple claims, but you're looking at an overall case docket for all IP cases of over 400,000 cases, which is huge. And patent cases are probably, I don't know, about 10 to 20,000, also a lot larger than the United States. Foreigners play a relatively small role in the docket, at least according to official data. And the cases, as in other countries, including the US, tend to be clustered in courts that are well regarded by the foreign community or by the business community, Beijing, Shanghai, Guangzhou, and the like.
Thank you, that was very informative. Jing, there have been several important patent disputes in China in the context of standard essential patents. Do you think you could provide a brief overview of some of the most important cases? What, in your view, are the most critical issues addressed in those cases?
Yes. All the cases involving standard essential patents actually is a very special type of patent disputes. It's somewhat different from the traditional patent litigations in China. Now, we've been seeing a line of cases in the last few months, starting around the summertime, now all the way to Christmas. I think for our international friends, the 2 most well-known cases involving the Chinese implementers. One is between Xiaomi versus Interdigital. The other one actually involving a non-Chinese implementer, Samsung versus Ericsson. So in both cases, the Chinese courts in Wuhan issued this anti-suit injunctions. And then later on, the other courts, one is in the US courts, in the Ericsson case, issued the anti-suit injunction against the Chinese anti-suit injunction. In the Interdigital case, between Interdigital and the Xiaomi, the Delhi court issued the anti-suit injunction. So both cases really actually caught everyone's attention, even actually very surprising to lots of us in China, even though we have heard about the potentials in China in terms of anti-suit injunction. But when it came, we're still somehow surprised. In the Xiaomi case, in the Xiaomi versus Interdigital case, the Wuhan court issued an anti-suit injunction enjoining Interdigital from proceeding with the injunction, interim injunction, and permanent injunction in Indian court. And in the Wuhan case between Ericsson and the Samsung, actually also the same court issued anti-suit injunction asking the Ericsson not to proceed with the global friend rate cases outside of Wuhan. The same kind of request or injunction also happened in the Interdigital case as well. Well, actually, it's even before these two cases, the Chinese Supreme Court, IP court, that's the Federal Circuit type of court in China, issued the anti-suit injunction between Huawei and the Conversant case. That's actually that case is more worth noting because that's actually almost the first time the Chinese Supreme Court issued this anti-suit injunction. One of the key holding in that case is that the Chinese Supreme Court said that well, in China, the Nanjing court already issued this local friend rate setting for China for the Conversant case. Now, the German court issued the injunction where the friend rate is almost 18 times higher than what was said by the local Chinese court. So that will eventually thwart the whole thing in China. That's why the Chinese Supreme Court enjoining Huawei from enforcing that German court decision. So that's actually the case is probably issued at the highest level we've been seeing in China for the anti-suit injunction. More than that, we saw another case which is almost nearly not reported by the global press in Shenzhen. There's a case between Oppo and the Sharp. And also it's a case about a standard essential patent friend rate setting. Reportedly is even about a global friend rate setting. In the same case, in that case, the Shenzhen court issued the anti-suit injunction prohibiting Sharp from going through their patent litigation in Germany. It's actually even having a preemptive language in that injunction, which is prohibit even Sharp from doing anti-suit injunction in Germany. So you can see in those cases that in all these cases, the anti-suit injunction, anti-suit injunctions really happened between Chinese court and the courts outside China.
Thank you. Very interesting. Vivienne, maybe let me start with a very general question. So we have heard about the general characteristic of the patent litigation in China and about these specific cases. So how do this, in your view, how do these patent disputes compare to other commercial disputes in China? Are there any specific characteristics of the Chinese legal system that are particularly important for disputes and dispute resolutions?
Mark already covered some of the basic points in relation to litigation in China. I think a point that we have to make is that actually the Chinese have proved to be extremely litigious now that the court system is actually up and functioning. They have millions of cases going through, and most of those are actually civil cases. But there are a number of developments which I thought I would touch on in relation to the development of the Chinese court system, because in fact it develops in two different tracks. And one of these, which we have to be aware of, is that the Communist Party is engaged in a process of tightening its control over the judiciary and the courts. There's a whole program which has just been announced, the sort of 2020 to 2025 program, in terms of ensuring that judges stay in line and the courts operate in accordance with the correct ideology. At the same time, the courts are busy trying to improve themselves and reform their processes and procedures in order to make litigation more efficient, and particularly in order to try and improve enforcement, which is a perennial problem within the Chinese court system. Now, to a Western eye, it's a bit difficult to see how these matters can actually proceed side by side. And it's quite easy, I think, just to focus on the actual litigation rather than the aspect of the sort of shadow of party control. But it is actually quite important, particularly when we look at highly politicized issues such as FRAND and the standard essential patents, which are not just purely a matter of litigation. They also have very substantial political aspects. In terms of recent reforms, a lot has been going on during 2019, 2020 in trying to actually improve the operation of the courts. There's a substantial emphasis on internationalization or the use of Chinese law. And the way this manifests itself, in fact, is in terms of trying to attract dispute resolution to China. And so the sort of steps that have been taken have been setting up, for example, the Chinese International Commercial Court to attract litigation for cross-border disputes, although in fact, despite its very high quality judiciary, it's heard very few cases. There have been various initiatives which have been furthered, such as the one-stop diversified dispute resolution, which aims to combine mediation and litigation in the court system. And as part of this, the courts are trying to attract, or the governments are trying to attract, foreign arbitration institutions to set themselves up in China, offering the possibility of participating in this sort of integrated system, and trying to attract generally sort of foreign language litigation by allowing the courts to use, in the case of some of the courts, English language pleadings or appearing in court in person. So there's been a good deal of work there. On the front of procedures, improving procedures in litigation, an enormous amount of work has been put in by the Supreme People's Court in order to update all of the existing procedural matters because of the inception of the new civil code, China, which started at the beginning of this year and combined a whole lot of civil actions together. So the work there is very substantial. And this has included a lot of work in relation to intellectual property as well. So as Mark pointed out on his blog, in fact, there are guidelines for the enforcement of intellectual property judgments, but there are also quite a lot of other numerous updated interpretations relating specifically to enforcement. I mean, one thing which I've always wondered about, and maybe Jing can answer this, is, you know, you get these enormous judgments in Chinese courts, but historically it's actually been quite difficult to collect on them. And it would be interesting to know how successful, for example, New Balance is going to be in actually getting paid out the enormous award that it recently achieved in its dispute. But along with this, we also have an increased emphasis on cases and precedent. So the court has been issuing a lot of guiding cases, and a lot of these actually do relate specifically to intellectual property, with the purpose of trying to make the junior courts actually search out what cases have been decided and try to get some sort of consistent decisions, which is a very positive development. At the same time, there have been various agreements entered into with Hong Kong, which allow, for example, for interim measures to support arbitration, which should make enforcement of arbitral awards and potentially enforcement of Hong Kong judgments ultimately more effective in China. But at the same time, China is getting much more cautious in relation to IP judgments. So the various instruments that China has entered into tend to be to exempt IP or large elements of IP from the question of enforcement in terms of international judgments. So the development of the Chinese courts, as I say, is very promising in many respects. But in other respects, I think we always have to remember that these courts are operating in China. They still maintain the system of the adjudication committee, which means that when you appear before a court, if it's a serious or difficult matter, the panel which hears the case doesn't necessarily make actually the decision in the case. The adjudication decision, which is the president of the court and various other senior judges in the court, will actually decide what the decision in that particular case is. And this, of course, means that if it's a political case, then there's even more possibility for sort of the line to come down from above and what the decision in the particular case should be. So as with all of these things, I think we can say that there are positive developments and not so positive developments.
Thank you. And let me ask again you, Vivienne. We heard from Jing about the use of all these anti-suit injunctions in various litigations that, of course, companies had parallel litigation, but some of them were in China. And so cases where Chinese and foreign courts are asked to rule on overlapping disputes are certainly not new, but they seem to be increasingly relevant, particularly in the context of standard essential patents. And how do Chinese courts approach cases involving overlapping disputes, and does their approach differ from the approach adopted in other jurisdictions?
Well, I think that we have a bit of a problem generally worldwide in terms of parallel litigation. Chinese courts, rather than talking about comity as Western courts tend to, I have to say we talk about comity, we don't necessarily practice comity. Chinese courts actually are more focused on the concept of judicial sovereignty, which I always find rather a worrying concept, because it goes back to what I was saying about sort of drawing cases into China rather than sending them out. But they do actually have a number of major problems when it comes to parallel proceedings. There's a recent SPC opinion which talks about dealing with parallel proceedings in accordance with Chinese law. The trouble is that Chinese courts don't really have a lot of mechanisms to deal with parallel proceedings. They follow a civil law system essentially, whereby if a case is presented to them and they have jurisdiction, as they often do, then they will hear that case. And they won't actually refuse to hear the case on the basis that someone else, which is better suited to hear the case, is already hearing it, until such time as there's been a judgment in the other case which has been enforced in China. Now, the second prong of this, of course, is that it's extremely difficult to enforce a foreign judgment in China. And it's unlikely that a foreign judgment would be enforced if a Chinese court was actually hearing the case at the same time. In fact, generally speaking, it's extremely difficult to enforce a foreign judgment in China unless you come from a country which actually has a judicial assistance agreement. And even there, it can be quite difficult to enforce a judgment under a judicial assistance agreement because of the procedural hurdles that stand in your way in terms of enforcement. Most Western countries don't have judicial assistance agreements with China, which makes this even more problematic. Although every time a Chinese court does enforce a Western judgment, there's much excitement and people writing about how this indicates a change in the Chinese approach. In fact, it doesn't really indicate a change in the Chinese approach. And I think that this is really a matter of policy. The third aspect of this is that in terms of refusing jurisdiction, although there is a sort of rather basic concept of forum non-conveniens in China, that is whereby the court exercises its discretion not to hear a case because it has no connections with China. And there's a recent Supreme People's Court case which got a lot of attention because they did in fact support the concept of not hearing a case in the particular circumstances. In order to actually attract this document, you had to show that there are no links with China whatsoever. And that actually is generally pretty difficult to do, because the reason someone's brought a case in China is because they are pretty confident they can establish some sort of link with China. So in terms of parallel proceedings, it's really very difficult to actually persuade a Chinese court not to take a case. If you turn up and argue jurisdiction and you lose, then as far as the Chinese court is concerned, you've actually submitted to the jurisdiction and they will go along and hear the case anyway. And of course, if you then participate in the proceedings, as far as a foreign court is concerned, you have submitted to the jurisdiction, and then you're stuck with whatever the results are in the Chinese court. So Mark, of course, is I think better qualified to talk on the anti-suit injunction part. There have been quite a few anti-suit injunctions issued, particularly by the UK courts, to stop people from bringing cases in China, which have generally been ignored. China, I think, is backing up its anti-suit injunctions with heavy fines for people who don't pay attention to them. But, you know, enforcing anti-suit injunctions as a way of maintaining the integrity of your proceedings is, I think, generally problematic on a worldwide basis.
Thanks. Mark, I think you have been called. I know you have written a lot on this topic of anti-suit injunctions. Are there any problems with the use of such remedies in your view?
Yeah, so actually, it might be useful to dial back a little bit before even talking about anti-suit injunctions. I think it's important to know the context. Anti-suit injunctions are under Article 100 of the Civil Procedure Law, dealing with action preservation measures, and you can have them at different stages in a proceeding. But before China had these Article 100 remedies, in the patent, trademark, and copyright context, you had the possibility of preliminary injunctions on standards pretty similar to the United States or other common law countries to stop an irreparable injury. They were rarely granted by the Chinese courts, very rarely granted. And when they were granted, it was in a highly opaque manner, because basically this was a procedure that involved hearing a case before the trial actually commenced. It was handled by a separate division of the court called the Case Acceptance Division, and no one really knew what happened. So China would say that 90% of the requests for a preliminary injunction were granted, but in fact, a very low percentage were accepted. That kind of a difference in terminology that was very significant. The other thing is, as the legal system progressed, the law was changed, China really didn't need an anti-suit injunction in some of the earlier SEP cases. Why? Because of this highly valuable injunctive relief that you could get from the Chinese court and that you could get on an expedited basis. The average time to completion of a case from initiation in China of a patent case is 7 months. On appeal, it's 3 months. So you can imagine that in China, you will have exhausted your appeals before a US court has commenced discovery. So what would happen, and this happened in the Interdigital Huawei case around 2014, is a Chinese litigant could initiate a case in China after a US case was commenced and have a final decision and an injunction against a foreign party very early in this stage of the case. And if the injunction involved manufacture and the like in China, probably the foreign party would be compelled to settle. This was also the case, I think, with respect to Huawei and Samsung. So these are very valuable remedies. I think it's important to keep them in mind as we talk about anti-suit injunctions. The first anti-suit injunction that I'm aware of in China did not involve intellectual property. It was a maritime case in Wuhan. I think it was an anti-suit injunction involving an arbitration, if I recall correctly. What is interesting is, of course, that the courts decided from there that this is an interesting remedy. We can leverage it in intellectual property cases. And it was also a novel remedy. Anti-suit injunctions are very common in common law systems. Typically, they involve courts of equity issuing anti-suit injunctions against courts of law in the old common law system of the UK and elsewhere. But it was really novel for China, and China decided it needed to play the game. But before that time, before the Wuhan maritime case, Chinese courts would just ignore foreign decisions and just proceed. So what's the difference today between issuing an anti-suit injunction and only a few years ago where the courts might ignore foreign proceedings, or they might issue an injunction that would really conclude the case because they were leveraging the Chinese market? I think the real difference is kind of what Vivienne alluded to, which is the desire of the courts to exercise their judicial sovereignty and to be a player, if not the dominant force, in settling global FRAND disputes. So they're using this remedy that was previously quite rare, that is the availability of some kind of injunctive measure before a case really is deeply underway. And they're using it now fairly extensively to address what they view as an industrial policy problem, that if other courts are going to establish high royalty rates, and Eugene just mentioned one case where the German court was 18 times higher than the Chinese rate, this would adversely affect China's industrial development, particularly its role in being a player in manufacturing cell phones and infrastructure and developing 5G or even 6G technology. And I think that is probably the most significant difference. And to that extent, the anti-suit injunction remedy is also in line with previous Chinese government positions, not so much on patent litigation, but on the role that China should play as largely a consumer of technology that is being used for manufacturing. If China can lower those costs of production, which is royalty rates, it will make its manufacturing that much more competitive.
Thank you. And now maybe I have a general question for everyone. Mark, you mentioned this issue of setting FRAND royalties for the global portfolio of standard essential patents. And the first such decision that we saw was actually in the UK by the UK Patent Court, and then which was subsequently confirmed by the UK Supreme Court in Unwired Planet v. Huawei. And Chinese courts have subsequently also signaled their intention to set royalty rates for global patent portfolio. So do you see this as problematic?
You know, speaking personally, I think that Chinese courts certainly have jurisdiction to set FRAND rates for their own country. If the parties are willing to have China adjudicate a global rate, that's acceptable. What we've seen is that Chinese courts have also taken steps through various guiding documents to determine what constitutes a reasonable negotiation process and when a party has been unreasonable. So China, particularly in the Guangdong guidelines on SEPs in the telecom sector, China is not only really dictating FRAND rates, but to a certain extent it's dictating behavior. Because if you don't conform to that behavior, then the courts will issue an injunction. And if you do conform to that behavior, then they may not issue an injunction. So there's a bit of mission creep, if you will, in this effort for China to exercise some sovereign authority over its own domestic market. The other problem, of course, is that if you're dealing with a technology where China is, let's say, the consumer of the manufacturer of 90% of the products that the patents read on, which are cell phones. China's about 80 to 90% of global cell phone production. And the technology is in large part provided by overseas providers, at least traditionally that was the case. Then basically you've put China in the position of potentially setting global prices for technology, not simply setting the price of royalty rates for its own market through leveraging its ability to enjoin infringing behavior and to establish fair pricing, including use of the antitrust regime, which considers unfair pricing as monopolistic behavior.
Jing, Vivienne, any comments on that?
I think there's probably another way to say about what's really going on. I think a couple of years ago when I was in another forum talking about what's going on with the China's patent litigation, I used the words to say that I said, well, China is there's a lot of progress, but we probably have not really passed a big test, which really means that a big patent litigation between big rivals, especially when you involve maybe large Chinese local companies or state-owned companies in a very significant patent litigation, or maybe pharmaceutical or wireless communication. So far, we have not seen those big cases where we really got this big results where we saw that the Chinese court has done everything to give the results that all the parties are find that very creditworthy and then well analyzed. So far, we have not done that. But right now, what we're seeing is that whether they're a big test or not, our Chinese court jump into these big games. I think our court even create these big games in response to what we perceived as something that we probably feel more like a threat. A couple of Chinese judges wrote the reports on the static essential patents, which is quite revealing. The one big thing they quoted is what Urška used to mention, this the UK Supreme Court case on our planet versus Huawei and a couple other cases involving on our planet cases. To Chinese judges, I mean, they even said that they saw that more as a threat of what the Chinese court should have been doing. The logic is pretty simple. The logic is that, most of these phones are manufactured in China. We have one of the biggest markets. It's actually more natural for our Chinese court to have a say about this FRAND rate, whether the China rate or now even global FRAND rate. So that's a plain logic. And our Chinese court actually saying that we should do this. Now, the problem is that as a lawyer, when we actually involved in a couple of these cases, at least one thing I'm not convinced, legally speaking, is where does the jurisdiction come from? For some of the cases, when you saw how the Chinese court had docketed these cases, the way our Chinese court docketed these cases as a contract dispute, not a patent dispute. We talk about patent disputes, that's a more general term, but our Chinese court docketed as a contract dispute. And the logic is that, well, friend is supposed to be an offer, right? Legally binding offer. There's something about close to the contract. And that's why the Chinese court said, well, when the implementers are happy about the offer friend rate, they can come to my court. And then I saw this more as a contract dispute. But the problem is that there's really no contract concluded yet. Even under the Chinese law, okay, there's a certain very clear legal test about when the court have the jurisdiction over especially foreign related contract disputes, cross-border contract disputes. Here, the implementer basically forced the patent owner to be in the Chinese court proceeding to decide on a friend rate, which is a key element to a potential contract. This is a very, very controversial, even under the Chinese law. Now, we know that in a Chinese Supreme Court decision decided by a very well-known judge, Judge Zhu, and he said that, well, the friend case involve both torts and issues and also contract issues. So there should be a mixed test, involving all the contract dispute and the torts cases. So that's the court. You can find that the judges find all kinds of ways to justify jurisdiction. But right now, I'm not really convinced about it. We are fighting very hard about the jurisdiction. What's really interesting is that in a very recent development, the Chinese Supreme Court issued this a new list of cause of action, which has allowed the courts to docket cases. They now put this friend rate case under this category of a patent infringement case, not under contract anymore. They put this under, well, actually was never on the Chinese cause of action case listed before, but now they put that under this general patent infringement lawsuits. But the problem is that so far we have not seen any infringement issues be litigated. The implementer, it's very hard to imagine an implementer force a patent infringement cases against a patent owner. It's supposed to be the rights of a patent owner to decide where to litigate the patent infringement cases, not the other way around. So the logic is really stretching here. I think if you ask me where the problem is, I think the jurisdiction is one of the huge issue here. And also, as Mark pointed out in his blog, service process is also issue here. I'm the lawyer involved in some of the cases. I wouldn't comment on the details, but just to say that for all these cases, if you want to name in the Chinese court proceeding, if you want to name a foreign party as a defendant to do the service, normally Chinese court always follow the Hague Convention approach. That's still true by lots of courts, like for example, Beijing courts, they really follow Hague Convention. But in some of the local courts, in the Wuhan courts, in the Shenzhen courts, are really stretching the rules. They're using the mails, they're using actually emails. They even argue the emails are sufficient. I think that's actually really very troubling. That's the type of things that we are seeing that, but gotta be eventually have the clear ruling by the higher authority, by the Supreme Court, whether or not Chinese court can even use emails or mails without any notice to fulfill all the service process.
Thank you. And maybe just in relation to this discussion about global friend royalties and jurisdictions and anti-suit injunctions, some commentators have proposed that there might be a need for more arbitration or mediation. They have even suggested there might be a need to have an international tribunal that would be in charge for standard essential patents related disputes. Do you have, and that's a question for everyone, do you have any thoughts on these proposals?
I'm actually working on a paper on this very topic for Competition Policy International. I think ideally speaking, probably everyone agrees that arbitration will probably more appropriate for the friend cases because of the nature, the complexity, the nature of a cross-border will be really ideal for arbitration. We know that some companies have been tried this successfully. I mean, well, depending on how we, from what perspective, but successfully. We heard that Huawei, the Interdigital, tried this arbitration before, and the rate has been done. And then later on, there are, Huawei challenged that through the judiciary channel, but it failed. So from what we heard, anecdotally speaking, Huawei wasn't really pleased with the arbitration results. They probably think the rate was higher than how they expected. Generally speaking, that probably I think Vivienne and Mark probably have more of research about this. Generally speaking, Chinese companies are relatively not so comfortable about doing arbitration like outside China or going to another country for the arbitration on some major cross-border business. We heard that lots of Chinese company, big or small, they actually decided not to join those arbitration proceedings, even this means that getting a very disfavorable results automatically. So this is sort of there's probably some history here for the arbitration. I think eventually the big thing is that where we can find this arbitration place where both patent owners and the implementers are comfortable with, they can find some trust in this kind of arbitration panel. We recently did also a webinar, including international speakers and also our Chinese thought leaders to participate. And we're discussing, how we can really build this kind of arbitration system. I mean, arbitration center, maybe China-based arbitration center to handle this front race setting. I think eventually the conclusion actually pretty much, common sense. We really need a arbitrator, like a roaster that can be trusted, with all the right experiences and with all the good procedures. China has one of the probably largest arbitration center in the world. CTAC has been running for quite a long time, but they have not been given the trust to by the patent owner or implementer jointly to do the SEP cases yet. Can we really develop a system quickly? I think the possibility is always there. And the WIPO has set up a Shanghai center and probably Beijing center eventually for handling all these IP cases. Can we trust in our WIPO about this? I think WIPO definitely probably preferred choices by probably both Chinese company and non-Chinese companies. But we probably running, maybe running out of time. If the arbitration can be the choices right now, things need to happen fast.
If I could just add a comment there. I think CTAC, yes, is a very big arbitral body, but I don't think that it would have confidence of the major foreign companies in order to run arbitrations of this kind. A lot of their stuff is still domestic or at small scale disputes. Some of them are larger. I think the problem is none of the Chinese arbitral centers really have managed to attract non-Chinese arbitration. And so a lot of this therefore takes place in Hong Kong or Singapore or other venues for that reason. So it seems to me that someone like WIPO with their new tribunal, I don't know if it's had any cases, would be a neutral forum, which is more likely to get success. But it does seem to me that you have to have very clear recognition by everybody involved that these awards are actually going to be both enforceable and enforced in all the jurisdictions in which the FRAND decisions are made. And that's particularly China, which has been a bit shaky in terms of whether it will actually recognize awards which relate to things like IP or antitrust, because the question as to whether those things are actually arbitrable or not. So you would need to have a very clear regime in place, and I think agreed to at quite a high level all around in order to do that. But who knows, maybe now the US has a new regime itself, it might be possible to get these sort of negotiations underway.
Yeah, I think just to add to those excellent comments that in my view, what has probably changed things the most in licensing to China in the past several years has been the emergence of Chinese companies as licensors and not simply as licensees. And for that reason, China has more in the game. Chinese companies are suing overseas as well on SEP cases and other cases. It's still a relatively small percentage. I think Huawei is a plaintiff in about 30 to 40% of the patent cases, and ZTE is perhaps 10 to 20%. They're the dominant Chinese licensors. But that has been a game changer and suggests that China needs to think about how it can license out and how it can license in, and also how that will affect smaller players that may have less to cross-license or license with. At the same time, I think you run into two significant issues. One of them I've just mentioned is how much you have to pay. And if you have differences of 10, 20 times between what a foreign court might adjudicate, what a Chinese court might adjudicate, there's a possibility of doing something Solomonic and splitting it in half. Some companies may not want that. They may feel that this is a fair rate. And if they're an implementer, depending on other markets, they may feel they'll be happy with the 18 times rate in Germany or the US, and they'll forgo the Chinese rate or get whatever they eke out of that. So they may not find an arbitration where that is at risk all that comfortable. The second question is on the Chinese side. If this is really an issue of judicial sovereignty, as Vivienne points it out, or techno-nationalism, as perhaps a political scientist might point out, then it's not going to be easy for China to cede jurisdiction to an arbitral body, however composed, because it relinquishes power that the state feels is critical to its own development.
Thank you. June, I have another question for you. It's focused more on antitrust. So in the United States and in Europe, there has been an important shift lately in the antitrust approach towards patents, particularly in the context of standard essential patents. Competition authorities are no longer willing to intervene in cases where they would have to assess the fairness of a royalty level. Similarly, they are also not willing to impose an antitrust liability on an SEP holder simply for requesting an injunction. Has there been a similar shift in China's antitrust law or policy?
Well, at least in the last few years, the Chinese antitrust regulator has been relatively less, in high profile in IP cases. After this investigation into Qualcomm, a few years ago, Chinese regulator handed out a big fine about, I think around like 1 billion RMB against Qualcomm for this licensing practice in China. After that, at least there are there are very few very highly reported antitrust cases in the IP area. But however, just the last month or so, we saw this is a very important speech by our President Xi on the IP protection. In one of the key aspects, the IP works, President Xi links the IP to national security. This is a very new development. And there are some very brief points mentioned in that part. But what it seems like China nowadays have a particular note of this export control issues and also IP misuse when it comes to IP. And in that speech, that antitrust was frequently mentioned as a tool to deal with a potential negative part of the IP misuse. So we are actually watching this closely to see how this grows. For the anti-suit injunction we just mentioned, for each of the cases involving front rate setting, there's always a private anti-suit antitrust cases brought up by the Chinese company and by the implementer. This means that there's always antitrust cases in parallel to this friend case. This is a phenomenon. The Chinese regulator has not, well, at least we have not seen the reports of any new investigation in this area, but we wouldn't be very surprised if the regulator somehow saw there is this IP misuse angle in all this friend rate setting and restarted some new investigations. So this is something we have to wait and see.
Interesting. Let me conclude with one last question for everyone. As I'm sure you have seen, in January, the European Union signed an investment deal with China, and the trade relationship with China will certainly be an important issue for the new administration in the US. In your view, what are the issues that the new administration should focus on when designing the developing the new approach with China?
Maybe I'll take an initial crack at that. Most of the issues we're talking about today, I would say all of them, are not in the phase one agreement that the US signed with China. Broadly, some of the phase one provisions on the courts might be said to apply, but in terms of the grant of standards essential patents, litigation of standards essential patents, anti-suit injunctions, the fairness of the remedy, transparency of court cases, Hague Convention issues, et cetera, it's not in there. And I think during the period that there was this trade war going on, China continued to aggressively develop its IP regime and also to develop its international relations on IP in trade agreements, whether it was the RCEP agreement or the Comprehensive Agreement on Investment. At the same time as the US was pulling out, I think many of us drew a breath of surprise when China's leadership said, yeah, we'd be interested in the CP, the agreement that the US led to negotiate kind of to exclude China. Now China might drop in and perhaps the US would be on the outside. So really very skillful diplomacy on the Chinese side and very unskillful diplomacy on the US side makes for a perfect storm. There's plenty of room to discuss these issues with China. And I think whatever happens bilaterally, because there are obviously a range of issues where the US does not agree with China, there's still a huge cohort of American businesses in China, Chinese businesses in the US, bilateral trade, patent, trademark filings, litigation, et cetera. And there's no reason those discussions shouldn't go forward to lower the temperature. And I think it would benefit both countries. We've had a politicization on both sides. I think He Jing spoke briefly about how matters have been politicized. You know, there are some bills in Congress that would address the CEP issue. I say address in quotes by, putting companies on the export control list if they don't pay royalties and the like. These start becoming, rather extreme when you look at them. And I think it would be regrettable if we couldn't find mechanisms through our courts and through diplomatic dialogue that could help resolve them. The Biden administration, though, to date on these issues really hasn't said anything. What we have no one appointed yet or nominated for the patent office, and certainly not a deputy level. And we have a nominee for the U.S. Trade Representative, but we don't know who the people will be on the deputy level. Historically, the folks in charge of intellectual property at USTR may have some tech background at the deputy USTR level, but they haven't come from, the hard IP community, the patent community, or from folks who've done patent examination and the like. So the background is a little bit more trade-oriented, perhaps, than deeply IP-oriented. And even on issues like antitrust, where there was what I thought was positive developments during the Trump administration, it's herding cats in the U.S. government on some of those issues. You have the FTC and DOJ with their positions, often not aligned, as we saw in the Qualcomm Apple case. You have USTR, which nominally has jurisdiction over internet matters. You have the PTO sometimes reaching out to DOJ or other agencies because of their interest in protecting IP. It makes it very hard to align decisions and policies, and then also to think about how they play out in China. I think it's still early. To judge by the appointments, we're not there yet. The administration seems to be ramping up on some antitrust issues. Congress is certainly very agitated. And I'm hopeful that we will find a way to bring back a measure of dialogue, which I think could help lower the temperature rather than have it continue to escalate as occurred over the past 4 years.
I'll just make a few quick comments so Jing can speak up too. I mean, I would say, as someone who has not come from the US, that I think what the rest of the world would like to see is considerable de-escalation. In particular, I think the fact that the US has actually now allowed someone to be appointed as Director General of the WTO is a positive step. And they should also start getting out of the way in terms of getting the appellate body of the WTO back and running. They should be stepping forward in terms of participating in all of these international organizations in which they've essentially let China have free rein during the last 4 years. So WIPO, other international organizations discussing the ISDS and so on. All of this, I think, is really very important. What I would like to see less of is these bilateral deals, which sort of have very unfortunate spillover effects for everybody but the US, and which clearly, in the case of the Phase 1 agreement, have not really benefited the US either. Because what it means, in effect, is that countries like Australia and Canada end up becoming proxies for China to sort of throw their weight around against because they can't get at the US itself. So what I would suggest in relation to all of these issues is that everybody steps back. The US steps up in terms of multilateralism and tries to get agreements at that level rather than trying to do side negotiations, which don't necessarily work.
So for my side, I think I actually highly agree with what Mark said about the CPTPP. I think China has a genuine interest joining the CPTPP. I think it'll be really great to look into very closely about all those requirements about IP protection in the CPTPP and then work around that and see what can come out of it. You know, one big thing I always think that we can easily produce results is probably more about the anti-counterfeiting and the anti-piracy. China has a huge interest to grow its own local brand and also grow the local creativity industry, like even movies, right? We have a huge market here. We're doing very well. So in all those areas, I think things can be done relatively quickly, and then China is pretty ready. And the second big part is actually the US-China Phase 1 trade agreements. China made a big progress in implementing those promises in terms of, at least in the law and the regulations when it comes to IP. I'm actually even pleasantly surprised, when I see that so many new rules and regulations coming out to implement that. But of course, a lot of work has to be done. I think China, at least from my side, I really saw that China really genuinely interested in implementing all those promises on the IP side. So those things should not be wasted on the trade secret litigation, on the pharmaceutical IP reforms, and a lot of things can be done. So I think for the new administration, all this IP work should probably focus on those two areas, then we can see lots of results.
Yeah, I just add one thing to integrate what Vivienne and He Jing just said. The comprehensive agreement on investment doesn't raise to the same degree the issues of most favored nation treatment that the Phase 1 agreement did, particularly in terms of purchase commitments. And in general, IP agreements also do not raise those concerns as well. If China changes the trade secret law, it's not just for Americans, it's for Chinese and it's for foreigners. If China has a patent linkage regime, it's not just for Americans, even though we have a big biotech industry, it's also for Europeans and Australians and for Chinese biotech entrepreneurs. So there's actually better prospects for eliminating some of the problems that Vivienne alluded to in the Phase 1 agreement, if the agreement is solely on intellectual property, because it will help everybody, including China's own desires to become an innovative economy by improving its IP regime. And I think that's part of the reason that even previously, even when there were very difficult times bilaterally, such as in 2007 when the US filed a WTO case against China regarding its IP enforcement, bilateral discussions on IP continued. And even in the middle of the trade war, there were still discussions between the US Patent Office and CNIPA. They were lower profile, perhaps less impactful, but they still continued because there's a recognition that we can learn from each other and that it doesn't need to carry the same political weight and problems of other issues.
I'm afraid that with that, we have come to the end of our time. Thank you to our speakers for this for the very interesting insights and for this very interesting conversation. I have enjoyed it a lot, and I'm sure our viewers have too. And thank you all for joining us.
Thank you.
Thank you.